we left off with Ms. Weinman offering testimony regarding her attorney's fees. A reminder of the time remaining to both sides. Mr. Champagne has 14 minutes remaining to him, and Ms. Weinman, you've got 24 remaining to you. Not that you have to use all of it, but that's what you got. Ms. Weinman, whenever you're ready.
Judge, I have prepared an attorney's fees exhibit. It is petitioner's 21 inbox. And my testimony, do you want to start me in?
You're an officer of the court, so I don't require you to swear out.
Okay. My name is Daryl Weinman. I'm an attorney licensed to practice law in the state of Texas. I've been licensed to practice since 1994. Since that time, I've had my own practice. I practiced primarily in Travis and Williamson counties, Texas. In 2000, I became board certified in family law. Since that time, I've practiced almost exclusively family law and in Travis and Williamson County, Texas. My current hourly rate is $5.25 an hour, which is a reasonable rate for an attorney with my experience and specialization in the Central Texas area. On my fee exhibit, and my paralegal, Tracy Todd, has been a family law paralegal for over 30 years. And I bill her at $195, which is a reasonable rate for an attorney for a paralegal with her experience. My fee exhibit is only through Monday, the 12th. We have since billed in preparation for this hearing just yesterday another $1,977. And for the hearing today, which is only at my rate, not anybody else's rate, for 3 hours today, be an additional $1,575. So in total, by the time we finish today's hearing, the total fees will be $8,916, and assuming another 2 hours of paralegal time and half an hour of my time to get the final order drafted, or the order from this hearing drafted, would be another $650, $250, and so the final total of attorney's fees billed would be $9,568.50, which I believe is reasonable and was necessary given the issues involved in this hearing. And I would offer petitioners 21 and then pass myself as witness.
Any objection to the admissibility of petitioners exhibit 21?
I'm going to object again that this was not received until yesterday evening. It is late.
I would remove your objection and admit petitioners exhibit 21. Any cross, Mr. Sheen?
Yes, I would like to cross-examine the witness.
You may. You know that the scope of relevant testimony here is the reasonableness and necessity of this case.
That's fine. First question. Do I have a contract with you, Daryl Weinman?
No, you do.
Do you have a sliding fee schedule for clients?
I don't personally have a sliding fee schedule, but I have associate attorneys in my office who I bill at a lower rate.
Okay. Have you ever handled a modification under Texas Family Code 156 before?
Yes.
Do you have templates and experience with this?
I use templates that I get from West, and yes, I have a lot of experience.
Okay. Are you familiar with the Texas Rules of Disciplinary Conduct that govern attorney's fees, specifically 1.04?
Yes.
What factors did you use in considering the reasonableness of your fees?
So the fees, actually, every year, about every other year, the TCFLA, which is the Travis County Family Law Advocates, it's a group of board-certified family law attorneys, conduct a study, send out a request for what everyone's rate is in the Travis County area. We also submit what our current rates are, what we bill our associates at, what we bill our paralegals at, so that we can look and see that everybody is within the same market range based on experience and specialization. So I've monitored my fees, and as they've gone up over the years with that.
And have you submitted this cost survey as evidence?
No.
And are any of those attorneys here to testify on their fees?
No.
Okay. Please identify each task you had to perform that you were seeking fees for.
So all of those tasks are outlined in Petitioners 21. There's, which you should have access to. I uploaded it to Box. I emailed it to you. But all of my billing statements are attached to the cover page, which is just a summary. And so every billing statement outlines everything that went into those hours.
Okay. And do you have evidence that the task as billed was done in the time increments as shown?
Do I have evidence? The evidence is my sworn testimony that each of those time periods as they were billed were noted at the time that the task was performed.
So you have no keystroke logs or video recordings of you doing these tasks?
No.
Okay. So we have to rely on your testimony that you did these as you said?
Yes.
Okay. For each task you've completed, list the factors you considered in determining the reasonableness of the fee.
We're not going to go through them one at a time, but I think if you look through them, you'll see that they are preparing responses to each and every one of your pleadings, your emails, putting together the discovery responses, appearing for the deposition, preparing for this hearing, communicating with my client. There's everything on there was reasonable and necessary.
Okay. Did you use a template for these pleadings?
Yes.
Okay.
We use form creation software.
And what software do you use to prepare these documents?
West Forms.
Okay. And when using West Forms, is this data entry that you have to put in?
I don't create those pleadings. My paralegal does. So you'll see on the billing statement, the paralegal creates the pleadings and they're billed at her rate.
Okay. Why is this case novel?
The issues, every family law case is novel because every fact situation is different. In this particular case, dealing with the number of pleadings that you have filed and the legal arguments that you've made, which are unusual, I've had to address each of those. I certainly don't have any templates to address your arguments.
How did you determine the novelty of this case versus other cases?
I think I just explained that. I don't have other lawyers or opposing parties filing pleadings like yours and making arguments like yours, and so they're unusual. Novel.
Okay. The methodology that you stated earlier, is this methodology duplicatable?
No. I mean, you can't duplicate my brain, so no.
So your methodology is not duplicatable, correct?
The exact methodology, no.
Okay. When was your cost survey completed?
Well, I didn't do the cost survey. I don't recall when the last one was. They're usually every summer.
Okay. The cost survey you used to set your fees, what year is that from?
I just monitor it every year. I haven't changed my rate in over a year, so.
Okay. How did you calculate the effect of your reputation as on performing your services?
My reputation, I don't think, is as important as my experience and education.
So you don't use your reputation to determine your costs that you bill for?
I guess it's a factor. I don't know how to weight that.
Okay, so you don't have a weighting scheme for that. You don't have a methodology for that particular factor. Okay. How do you expect your outcome, your reputation, to affect the outcome of this case?
I don't expect my reputation to affect the outcome of this case.
Okay. And why wouldn't a new attorney be able to achieve the same results as you?
Essentially, they could if they presented the same evidence and the same arguments.
Okay. I'd like to introduce Exhibit C. May I share my screen? Right here is the Bureau of Labor Statistics website. I've taken a screenshot of the Bureau of Labor Statistics. A keynote is right here, the Austin, Round Rock, Texas area. And what we have right here is lawyers, what lawyers are customarily paid in the Austin, Texas, Round Rock area. And we see that they have a median hourly wage of $59.17. How do you justify the reasonableness of your fees as performing the task of a family law attorney in the Austin, Round Rock area when the Bureau of Labor Statistics states that the median salary for an attorney is $59.17?
$5.25 an hour is not my salary. That is what I bill my clients at. That covers a lot more than just my salary. I actually do have a salary that I am paid by the law office. The office bills me at $5.25 an hour, and that takes into account a lot of other factors other than my salary.
Can you list me those factors?
I can give you some of them. Let's see, the rent, payroll for my other staff members, the cost of my computers, copiers, the monthly cost for hosting my website, my monthly cost for less law, less forms, insurance, continuing legal education. Those are the biggest factors.
Okay, and how much do each of those cost?
Judge, I need to object to relevancy.
Sustain.
I'd like to introduce Exhibit D. Exhibit D. This here is a similar document to what I just produced. This is the Bureau of Labor Statistics website for paralegals. Right here, we note that this is in the Austin, Round Rock, Texas area, and that we note that they have a median hourly wage of $27.74. Daryl Weinman, how do you justify the reasonableness of the fees your paralegal has billed when the Bureau of Labor Statistics lists the median salary of paralegals in the Austin, Round Rock area at $27.74 per hour?
Again, her hourly rate is not her salary. I don't pay her $195 an hour salary. The salary is one factor in where her hourly rate comes from. The hourly rate takes into account a lot of the overhead costs for running a law practice.
Okay,
You have 5 minutes remaining to petition hearing.
for cost, excuse me, Judge Howell, or overall?
5 minutes. You have 5 minutes remaining to.
Total or for cost?
Yeah.
Okay. Okay, let me finish this up. Real quick, I just want to ask, Daryl Weinman, are you aware that there's a bias in Texas against men?
I don't agree with that statement. But
Okay, I would like to present my next exhibit, Exhibit G. May I share my screen? Okay, we have here what the Office of the Attorney General has presented. That is the Handbook for Non-Custodial Parents. If we go to page 3, we read right here, many people think only fathers can be non-custodial parents, but this is not the case. In Texas, about 10% of non-custodial parents are mothers. Some of the information in this guide is directed towards fathers, but most of the information can apply to either mom or dad as the non-custodial parent. Are you now aware of this bias in Texas courts?
I disagree that's biased, but I do also object, Judge, that this is not only hearsay, but outside the scope of the attorney's fees.
All right. Let's see. What actions did you take to conduct a reasonable inquiry into the facts of the case that made you believe the instrument is not groundless and brought in bad faith?
What instrument is not groundless?
What you brought forward.
I met with my client, I reviewed her evidence, I reviewed the court file, and believed it's a valid cause of action.
Okay, I pass the witness.